if everybody's ready, we are going to get started with driver qualification, English language proficiency, and non-domiciled CDL. Half of them are still talking to the FMCSA back there, so if you want the real pros, you can ask them, but if you want to hear the rest of it, we'll tell you the rest of it. So I think one of the big reasons that I kicked this off with this year instead of what I typically talk about, we often talk about every year maintenance, and that seems to be a big topic, but with this year's issues in terms of English language proficiency, non-domiciled CDLs, how that pertains to driver fitness and driver qualification standards, and what we see with our clients, whether it's large strategic and enterprise clients or owner-operators that are being affected by these things, we've just felt it was the need that the industry needed this year, so we kind of left the maintenance side and gone to kind of the driver fitness piece. But what we're seeing is fleets are bypassing a lot of red flags, and I think it's important not to just focus on the fact that these things have come to pass in terms of regulations and laws, but it's also important to understand the fallout from them and how they can affect you, whether it's through post-accident litigation and highway accident litigation, et cetera. Well, we're seeing a lot of fleets that are bypassing the red flags. We're seeing applicant pools that are prioritizing quantity over quality. DQ files basically getting rubber stamped. It's that old check the box mentality where some of these tech systems are really good at giving you workflows and checklists in terms of what you should and shouldn't be doing from a reg perspective, but not always from a policy perspective. So just because you're compliant doesn't always mean that you're risk-free. So you can still have exposure regardless whether you're compliant or not. And that's one of the things we wanted to touch on.
You think we should introduce ourselves or no?
Yeah, after this one, but we can do it first.
Hey everyone, Brandon Wiseman, president of a company called Trucksafe and a partner with the Childress Law Firm, and Rob Carpenter with Trucksafe and all kinds of other stuff. You've probably seen him on Freight Waves and all different places, but we're always coming at these types of issues kind of from the regulatory, the legal perspective. Rob does a lot of testifying in highway accident cases as a compliance expert. I work with a lot of motor carriers and their drivers on trying to keep them out of the crosshairs. Not one of the billboard lawyers. I'm one of the good lawyers working for you guys, trying to make sure that we're doing things the right way so that we can best minimize our exposure in those types of settings. Not only highway accident litigation, but also from a DOT perspective and keeping your customers happy and that type of stuff. So when we're talking about these driver qualification issues, what we're seeing more and more, I don't know if you guys have noticed, but driver qualification has been under the microscope for the last several months here, driven largely by some of these things that we're talking about. English language proficiency, non-domiciled CDLs. I mean, just turn on the news, the national news. When was the last time you could remember trucking being so heavily emphasized in the national news? Unfortunately, it's being emphasized for a lot of the wrong reasons, that we don't want to be in the news. These high-profile crashes, and a lot of them involving issues of deficiencies in driver qualification. And so not a great place to be if I'm a fleet or a driver operating nowadays. Just you're under the gun here. And so we want to talk about these topics to make sure that, number one, that we fully understand what is changing, what's not changing, equally important, and also give you some thoughts on how we're kind of guiding our motor carrier and driver clients into thinking about these things to best minimize their risk, both from a DOT perspective and also highway accident litigation. So that's kind of how we're coming at it. As we go along here, I mean, we've always found these things to be more useful. If you guys have questions and we're not explaining things well, just raise your hand as we go, and we'll take them as we go. No need to wait till the end. So.
Well, he just introduced me too, so I didn't start off that way because I figured everybody in here knew who I was, as important as I am and all, but I am Rob Carpenter. Like he said, I've been driving trucks for 25 years, left the truck, became a broker, not sure how that happened, ended up running large companies, owning and selling a company, and then went into highway accident litigation, expert witness work. So that's a lot of what we do, a lot of what I do, and then we work together on helping companies be compliant. But what we were getting into in terms of the driver fitness aspect is basically focus on what we're seeing in our fleets, whether it's big fleets or small fleets, and ultimately what that costs. And nuclear verdicts are a big consideration for us, especially me. We see it all the time. When did we start here? Wednesday at the show? I think Tuesday I had a deposition, so I was already here for a deposition in a truck case. So almost everywhere we go, we can almost put these into the schedule to pay for the trip because there's so many of them and they happen all the time. But nuclear verdicts are averaging $22 million per incident. Insurance markets are tightening or they're exiting the space. Regulatory scrutiny tied to violation histories is hitting carriers hard. There's a pattern of litigation in some cases that we see. But how we ultimately want to guide you in how to fix these things is not just from a compliance standpoint, like I said earlier, it's more from a risk standpoint. Anybody can tell you about compliance. Not everybody's going to address the risk piece. So one of the pieces that we focus on is practical DQ file compliance, and we're not going to spend an eternity on that. We could be here all day on it. But we really wanted to get to the non-domiciled and the English language proficiency pieces and how you can add those into your driver fitness screening profiles for when you're hiring your drivers.
You want to go to the next slide?
Yep.
I want to reiterate something Rob said. I want to make sure you heard this clearly because this number is just astounding. Look at the first number on this slide. The average jury verdict award in a truck accident case that proceeds through trial to the jury, the average nowadays, $22 million. Crazy numbers. That is up over 1,000% over the last 10 years. And just the sheer number of these cases being litigated against truck companies and their drivers, just astronomical numbers that we're seeing. And so you don't want to be involved in these questions. Yeah.
Is that number specifically towards truck versus car, or is that including truck on truck?
It could be, the question is this specific to truck versus car, or could it also be truck versus truck? It's encompassing all of them. So these numbers are coming from a study that was put out by the American Transportation Research Institute. They actually have a booth here. They put out a lot of great studies on these types of issues impacting the industry. This data is from 2025. They looked at the full universe of cases, so-called nuclear verdicts, which they defined as any case involving a truck that's over $10 million. So they looked at the full universe of those cases over a certain time period, and this is what the average number came out to. And so when you start to dig into these cases and what's driving them, you will very quickly see a pattern. You can see at the second number on the chart here that 78% of these cases that end up in these $10 million plus jury verdict awards involve allegations of negligent hiring, some kind of deficiencies in the motor carrier's driver qualification process in bringing their drivers on board. Maybe they didn't do a sufficient enough background check on that driver. They weren't looking at their motor vehicle reports or something to that effect. All of that feeds into this narrative. It's called the reptile theory of litigation. You may have heard of this. It's a theory that the plaintiff's bar has become very aggressive in prosecuting and also very talented in doing so. It's really a way to manipulate the minds of jurors into getting angry at the trucking company for not following the rules. And maybe some of those rules didn't even have anything to do with the accident that's being tried, but they inflame the minds of the jury such that the jury wants to do something to punish the motor carrier or the driver involved in the case, and the tool that the jury has available to them to do so is through what's called punitive damages, damages intended to punish the company or the driver for their bad behavior, and that's where we are seeing these multi-million-dollar jury verdicts. So just a huge swath of these driven by missteps in the driver qualification process, which is what we're trying to curb when we talk about things like English language proficiency and non-domiciled CDLs. We also see a huge uptick. These cases have become so lucrative to be involved with for some parties that we now have third parties that are financing the litigation on behalf of the plaintiff's bar and those that are prosecuting these cases. We see huge fraud rings popping up where some plaintiffs' attorneys have been thrown in jail for the way that they staged these accidents because they have become so lucrative to be involved with. So yeah, just a bad situation to be in if we are a modern day motor carrier or the driver is working for them. Yeah, other question?
On the English language proficiency, can the carrier be held liable for discrimination if, say they speak English, but it's broken, and even I have trouble understanding of it?
Yeah.
If I use a driver for that, could I be held liable?
The question is about English language proficiency. We have a specific slide on that, so I'll come back to your question when we get there. No, you're good. No, I told you to ask questions, so that's my fault, but we'll get to it.
This would get very boring if you didn't ask questions. So I'm glad you're asking them. But real world cases that we see, last year, I think a lot of people had heard of different things, and a lot of people mix up non-domiciled and English language proficiency and the court cases and all the other things and the noise that goes on around them. But the first case that really hit this off, I think that kind of got everybody focused on it, I think was the Harjinder Singh U-turn crash that happened in Florida last year. Everybody then suddenly became hyper-focused on it, and then every single crash since became a huge news story. So we wanted to focus on some of the driver fitness issues that came with Harjinder Singh. For instance, he failed multiple parts of his English language proficiency piece following the crash. So one of the pieces, and we're going to get to this shortly, that you can actually look at when you're hiring drivers, and you can add this into your workflow, actually testing them for English language proficiency. And Brandon actually created one with using a similar or the same standard that enforcement uses on the roadside. So when you're bringing these people in to actually employ these drivers, you can actually give them the same test that enforcement's going to give them on the side of the road, actually have a certificate to put in the DQ file, and you can say, hey, on this date, before we even put them in the truck, we actually gave them the same test that you just gave them, and we basically certified that they could speak English. It's part of our risk profile. Now, FMCSA is not going to require you to do this. This isn't something that's regulatory required, but it's something good to have to cover yourself if they have the crash, and then and you're asked in court, why did you hire somebody that couldn't speak English? He could. We checked him. So it's good to have in the file. But there's other aspects that you can actually look at in terms of this as well, in terms of the overall DQ file and their non-domiciled status, actually validating their immigration status. And one of the things that I often see when I'm auditing files for different companies, we have one company that had hundreds of CO8, which under the CO8 immigration status, it's an asylum applicant, which that is no longer allowed to be, you're not allowed to hire drivers in that status anymore. So if that driver were to get into a crash, you could face more exposure after the fact. So it's important to not only check the English language proficiency piece, but it's also important to actually check their immigration status and make sure that you're going to have to get into this one, but make sure that their immigration status is what it's supposed to be and their documentation is what it's supposed to be.
Yeah, and then another case that's worth highlighting here, this one kind of flew under the radar, which I have no idea why it flew under the radar, because this is the first ever $1 billion jury verdict awarded in a truck accident case. This happened a few years back. This was another Florida case. Florida not having a great few years here from a highway accident standpoint. But some of you may remember this case. Connor Zion, college student, operating on, I think it was I-75 near Jacksonville. Traffic gets stopped due to a crash that had been caused by a driver of a carrier called AJD Business Services. That driver that stopped the traffic, the reason he was involved in the crash, that it turns out the evidence proved that he was on his cell phone while he was operating on the highway. He was over his hours of service limits, and he also didn't have a CDL when he was operating a vehicle that required a CDL. So many problems there that backed the traffic up. But that wasn't the issue in the case so much as the second driver that was operating a full tractor trailer was a non-English speaking driver that was coming down from Canada, had been operating for 15 hours straight, well in excess of his hours of service limits, also couldn't read and speak English, and admitted in the case that he was unable to read the flashing highway signs that would have alerted him to the fact that traffic was stopped ahead had he been able to read the sign. In any event, not paying attention, fatigued, slams into the line of stop traffic, kills Connor, and this case proceeds to litigation against both AJD Business Services, the carrier whose driver caused the original crash, and Kakashan Carriers, whose driver is the one that plowed into the line of traffic. Case goes to trial. All of that bad evidence comes out. All of the qualification missteps that both of these carriers had run afoul of the rules comes to light, and the jury returns the first ever $1 billion jury verdict award in that type of case. Is anybody ever going to collect $1 billion? No. Nobody's ever going to collect $1 billion, but the message is clear that if you are a carrier and you are not taking the time and the effort that it takes to put in these qualification foundations and making sure you're doing the right things, checking the right boxes, from a regulatory standpoint, that is all going to be exposed. God forbid you end up in one of these cases, and it's not going to play out well for you. I mean, these carriers are going to be shuttered because of this. They're not, they probably have the minimum level of insurance, $750,000. That's going to be quickly exhausted, and so they're going to be on the hook with their assets and everything like that, and they're just going to have to shut down because of it. So all it takes, clearly, is one of these accidents, and it could be lights out for you. And the best way to mitigate that is to make sure you are, at minimum, checking the boxes, doing the things that the rules require of you, and then on top of that, I mean, as we'll talk about, checking the boxes, following the rules is the floor of what is expected of motor carriers and their drivers. It's not going to be enough in these highway accident cases just to prove that you followed the law, unfortunately. The jury is not just tasked with assessing whether you followed the law. What a jury and a judge are assessing in these cases is, did you act reasonably under the circumstances? And you could check all of the boxes, and a jury may decide that you didn't act reasonably. Maybe you didn't do what other peers of yours are doing from a compliance and safety perspective. And maybe a jury decides that that was unreasonable of you not to keep up with the Joneses, so to speak, from a safety standpoint. So that's what we're going to kind of get into with these next slides, and I promise we're coming back to the English language proficiency issue.
All right, I think some of this is I think people kind of look at this and they think, well, this is here to scare us into being compliant. But I think there's more of this to understand in terms of really grasping your moral, ethical, professional responsibilities of being a truck driver. And I don't know that we always do. I know that I always didn't. When I first started, I was probably one of the worst truck drivers on the road. And that gradually changed over time after I recognized some of these things that happened. The higher flow is important, and the reason that I prescribe a higher flow in the way that I prescribe a hiring flow is so that you don't waste a bunch of money that's unnecessary. And what I mean by that is, you'll notice that after conditional offer and application, and you've reviewed this application for red flags, the very next thing is clearinghouse before you do anything else. And I think one of the things that is really wild is clearinghouse has been in existence for 6 years. We still go to carriers every single day that have never heard of FMCSA clearinghouse. So clearinghouse, if they come back as prohibited, you can't hire them. So there's really no point in actually starting anywhere else except clearinghouse. So starting with clearinghouse, if you get that not prohibited, then you move on to obviously the MVR, PSP, and we're going to talk about PSP in a minute, but PSP is not required. It's a service that's offered by the government. It's recommended, and we're going to talk more about what the difference between MVR and PSP is in just a second. Next, check and med card, which now has changed. Obviously, you're validating that on their MVR. There's no longer that, let's get the med
CDL
card.
drivers.
Yeah, for CDL drivers. Then you move on to the drug test, negative result. It's associated with the clearinghouse, which is why that piece is there. The next part is what we're really here to talk about, work authorization and ELP check. You've checked everything else. You already have a requirement to do E-Verify in terms of from an HR standpoint. So you should already be doing that within the first 3 days of hire. But that I-9 completion, the E-Verify, and then checking English language proficiency, and then validating the non-domicile status. So one of the things that a lot of people aren't really understanding with this is with a a non-domiciled license, what was supposed to have happened was the CDL expiration was not supposed to exceed the work authorization expiration on the license. What we had happening was they were being given CDL licenses in some states where the work authorization expired long before the CDL did. So that's where you actually run into an issue, and you also have the consideration now of what statuses are actually allowed. You only have 3 different statuses that are allowed, and we're going to talk about those in just a second. Previous employment verification is the 7th piece where you're going and doing your VOE to make sure that you're checking past employment history with previous employers. And then the last stage is obviously you've got all the documents you need present, you've got a complete DQ file, your drug testing has come back, you've got a verified negative result, MVRs are good, everything's fine, and then you're good to hire at that point. But the big part is the new piece, which for us is a recommendation that you start checking your ELP and your non-domiciled immigration status of your drivers.
Yeah, real quick, kind of along those same lines, before we dive deeply into both of those topics, going back to kind of the check the box deal. You have to, at minimum, understand what the rules require of you. Assuming you are operating interstate, when it comes to driver qualification, there are very specific rules that govern what you have to do when you are onboarding a driver. What documents do you have to get initially, and then periodically thereafter, updating certain documents. And there's just a list of them. There's no good reason to not just download this list and make sure that you're checking these boxes for all of your drivers. I'm not going to dwell on this because, like Rob said, we could spend 2 days we have spent 2 days talking about nothing but this. But so if you want to get a picture of this or whatever, I mean, this is the list of things that should be in a federally regulated driver qualification file per Part 391 of the safety regulations. There is one mistake on this, unfortunately. we forgot to take it out. It's an old holdover requirement that no longer is required. It's that list of violations, the annual certification of violations. That's the thing that the regulations used to require. Drivers would have to annually give their motor carriers a list of all violations that they had incurred, but the FMCSA took that out of the list of requirements a couple years back, and now they just get that information from the motor vehicle reports that they run. So everything but that one are things that you should just have as a matter of company policy to make sure that you are getting. It's the things that should go without saying, right? It's, a signed application, and you could get as technical as you want. If you dig into Part 391 of the regulations tell you exactly what questions you have to be asking of your drivers in your DOT application. Motor vehicle report, road test, or equivalent of a road test if you've got CDL drivers, annual review of their driving record, the medical cards, national registry verifications, drug and alcohol clearinghouse queries, pre-employment drug screens, all of that stuff. All of the stuff that you would expect is, and again, checking the box. And then in terms of what you could do above and beyond that, what are other motor carriers doing that goes beyond just the mere compliance aspects? These are just some of the things that we see other fleets implementing that you should at least consider. We're not saying that you have to do everything that every other fleet is doing, but you should be aware that other fleets are doing these things for that reason I already mentioned, that God forbid you end up in highway accident litigation, you're going to be assessed against your peers. And if your peers are doing things that would have prevented the accident that your driver got involved with, and it was reasonable for you to have done that same thing and you didn't, that's going to be a point against you in that type of litigation. So, just some of these things. Again, these are not necessarily required by rule, but are being done by others. Fit for duty assessments, criminal background checks, which are not required by safety regulations, but are good practice, particularly in certain segments of the industry, household goods, moving, white glove delivery, that type of stuff. It makes a lot of sense to do criminal background checks in those areas of the industry. PSP reports, and then you could just go down the list there.
One thing I'll add on that one before I move on to this MVR PSP piece is the CDL in lieu of a road test. How many? I'm assuming there's a bunch of people besides me in here who have a CDL. Yeah. How many would you agree that everybody who has a CDL is a great driver? Okay, that's what I thought. So The crazy thing is people will come in, they'll give you a CDL, and you'll immediately put them in the truck without actually riding with them to make sure that they can drive the truck.
Because the rules allow it.
Because the rules allow it. But it goes back to that risk piece where, do you want to be compliant, or do you want to actually check how much exposure you're putting on the road when you hire this person? So I don't care if you have a CDL or not. I'm probably going to ride with you for at least 10 miles and make sure you actually know how to drive a truck, especially if I still have stick shifts, and you've only ever driven automatic. So we're gonna take a ride. MVR and PSP, they're not the same thing. So I'm not going to go through every one of these. You can take a picture, but I'm going to tell you the quick and dirty difference. And the quick and dirty difference is with MVRs, when I left driving a truck, I had a spotless MVR. Brandon hates this story. I can see him squirming over here right now. So when I left driving a truck full time, my MVR was spotless, and it's a Virginia CDLA. It has all the bells and whistles, and it was spotless. +5, best record you could get on an MVR. The reason is I didn't have any convictions, and that's because I could talk out of every ticket that I ever got. So you pull the PSP, it was 6 pages long, and that's how good that I could talk when I was in roadside enforcement inspections. And I always got warnings, so it never went on the MVR, but it filled up my PSP. So what people were getting was this fake MVR persona of how I was driving, because I was actually not getting the convictions. I was just getting the warnings at the roadside and the violations at the roadside. But if you want the big picture of who this person is and how many 14-hour violations they have, or 70-hour violations they have, or bad tires or bad lights, are they doing, or do they know how to do a pre-trip? Are they doing a pre-trip? Will they do a pre-trip when they work for me? You run the PSP, and you're going to get a much bigger picture on who that person is that you're trying to employ to put behind your wheel. So that's the big difference.
Yeah, because in a nutshell, the PSP is pulling from the FMCSA's own data. You know, carriers have CSA scores. I'm sure we've all heard about CSA scores. PSP is the driver analog of the CSA system. It's pulling from the same universe of data that the FMCSA has available for all roadside inspections that driver has been involved with over the last, how many years does it go back? Is it 2 years?
I think it cycles out every 2 or 3 years.
2 years worth of data. So if a driver candidate is coming to you and you only pull an MVR, to Rob's point, you're only going to see potentially convictions, things that they have been convicted of. It's telling probably not even half the story. If you also pull the PSP report, which is not required but a good practice, it will give you the full picture. It will show you any roadside violations that they've been written up for in the last 2 years, any crashes that they've been involved with. I think they go back 3 years, if I remember correctly. So yeah, a great thing to have, and not all that expensive. What are they?
$10.
$10 each. So.
And if you have one, I mean, I run mine every year just to make sure that, I mean, there are people that create fake identities for drivers, and I check mine every year regardless, but it's $10. You can go in there and run it yourself if you have a CDL.
All right, so getting into the two main issues that we're dealing with, that fleets and drivers are dealing with, or at least hearing about in the national news and from FMCSA. If you were here earlier for the session, you heard them talk about these new crackdowns on enforcement. One of the areas in which they have cracked down recently are on these so-called non-domiciled CDLs. I talk with a lot of folks that weren't even aware of what non-domiciled CDLs are to begin with, so it's worth taking a couple minutes here to just talk about what they are and what they aren't. Non-domiciled CDLs have been a component of the federal CDL program for a few years now. These are not new things. They are a variety of CDL that are issued in one of two instances, and one much more prominently than the other. When they were originally built out in the regulations, there were two visions for when they would apply. The first one never comes up. But one legitimate reason for somebody to hold a non-domiciled CDL under the rule would be that, let's say that I'm a resident of a particular state, and for whatever reason that state has been decertified to issue CDLs. Maybe the FMCSA isn't happy with the way a particular state is administering the CDL program, and FMCSA tells them you can't issue CDLs anymore. It's never happened before. California's kind of at risk of that possibility based on its actions recently, but it's never happened before. But if that were to ever happen and FMCSA yanks a state's ability to issue CDLs, well, what happens to all of the citizens of that state that want to keep their CDL? You can't just go to another state and get a regular CDL if you're not a resident of that state. So what would you do? What you would do is go get a non-domiciled CDL from a neighboring state, which means I'm not a resident of your state, but my state can't issue CDLs, so I need a way to get a CDL so I can operate in the country. So that would be one legitimate way to get a non-domiciled CDL. Not a foreign driver, a U.S. citizen getting a CDL from a state other than the one that they live in. But again, since that's never happened, no state has been decertified, we don't actually see those being issued in that context. The second context where non-domiciled CDLs are allowed by rule, this is the issue that's under the spotlight now, is a situation where you have a foreign driver who's obviously not a resident of a particular state, and they want to get a CDL to operate in the United States. So how do they get one? If they're not a resident of a particular state, they have to go get a non-domiciled CDL. Of course, the rule has always included some guardrails around that. Who's eligible for these particular types of special CDLs? What do they have to go through? It's always been the case that there have been those guardrails. Only certain categories of foreign residents can get those. They were not supposed to be issued for longer than the work authorization that particular driver had. The licenses were always supposed to be conspicuously marked as non-domiciled on the face of them, and things like that. Those have all been baked into the rules. But as you heard from FMCSA, if you were in here for the last session, their nationwide audit found out that many of the states were not complying with those rules. They were issuing these non-domiciled CDLs for longer than the foreign driver's work authorization, which didn't make any sense. They were issuing them to foreign drivers who didn't hold the right type of immigration status. And so that landed us in a situation where now we've got hundreds of thousands of drivers operating on these non-domiciled CDLs in the country, and a significant portion of those were issued unlawfully, not in accordance with the rules that have been on the books for many years. So to get control of that issue, the FMCSA has issued this new final rule that even tightens those restrictions even more. And they have also issued directives to state DMVs to get control of the issue when it comes to administering these licenses. And so that's what you're seeing on this slide here. This is what the new rule does. It has now limited the available pool of foreign drivers who are eligible for these licenses. You could see them listed there in the first bullet point on the left. Only H-2A, H-2B, and E-2 treaty investor visa holders are eligible to get a non-domiciled CDL now, under the new rule. Previously, if you were a DACA recipient or an asylum seeker, you could also get a non-domiciled CDL. Those two groups have been cut out from the equation. They are no longer eligible to get a non-domiciled CDL. Just those three visa holders that are listed there in that first bullet point. Secondly, the driver's employment authorization document alone is no longer sufficient for them to prove their eligibility. Now they have to have an unexpired I-94 form and foreign passport in order to get a non-domiciled CDL. And then the third bullet point there is the big one, reinforcing that a state DMV cannot issue a non-domiciled CDL for longer than the length of the driver's work authorization or 1 year, whichever is sooner. So the longest a non-domiciled CDL is going to be valid for under this new rule is 1 year. That's the maximum length of a non-domiciled CDL going forward. It could be less than that if the driver's work authorization is less than 1 year, but it can never be beyond 1 year. And then all of these non-domiciled CDL transactions under the new rule have to be done in person and documents retained by the state driver's licensing agency for 2 years. You want to keep going with that? Go back real quick. A few recommendations here for carriers. We have a lot of carriers asking what they should do about this now. First thing I think you should do, the biggest thing I think you should do, is to at least take stock. If you're a carrier that has lots of drivers, for example, you should at least take stock of your existing driver pool and see, do I have any drivers in my pool of drivers that currently has a non-domiciled CDL? You need to at least understand how many of my drivers are potentially going to be affected by this new rule. Then beyond that, in terms of, do I hire drivers that have these non-domiciled CDLs? I mean, that's up to you. They can operate legally on a non-domiciled CDL for you under your US DOT number on our nation's highways. The concern you may have, though, is that their non-domiciled CDL is going to be limited term. I mean, your other drivers maybe have a CDL that's valid for 10 years. The non-domiciled CDLs that you're going to get are going to be valid for a maximum of 1 year. So it's going to be a short shelf life on these going forward. So that's, if you're going to hire drivers that have non-domiciled CDLs, that's really what you have to watch out for, just knowing that it's going to be a short shelf life on their ability to operate for you. And if that's not a problem for you, then they're lawful to operate on the nation's highways under that type of license. Let's see here. One thing to know about this non-domiciled CDL rule is that it is currently being challenged in federal court. There is a pending lawsuit against the FMCSA in the DC Circuit Court of Appeals. You may remember last year, the FMCSA tried to do this as an emergency rule that took effect immediately last October, and it got stayed by a federal court, by the DC Circuit Court of Appeals, because the FMCSA got sued back then, saying you didn't go through the normal process to get rules passed, and the court put a stay on the rule. Well, FMCSA did go through the process, and they issued a final rule. They accepted comments, they considered all of the comments, and they went through the process, and they issued a final rule that was effective March 16th. And so that's what's in effect now, but somebody has already sued them again, challenging the validity of the rule. That's going to have to work its way through that court system. The court may very well decide that they don't like the rule and they may overturn it, but we're just going to have to wait and see. So my point to you is just keep abreast of industry news. This is a dynamic issue. This is something that's changing quite a bit pretty quickly, and so it's worth watching the industry outlets about the current status of non-domiciled CDLs.
I think one of the things to point out there is, even though you have these court cases that are actually playing out, you need to actually evaluate whether it's something that you wanted to continue to do in terms of hiring these drivers. Because if it does continue on the route that it's going, you very well may have drivers that you won't be able to use anymore. We know carriers. We have clients that actually hire a large number of foreign non-domiciled CDL drivers. So those people have struggled through this because historically that's who they've hired. So they're facing issues with it now. You don't want to face those issues in the future. Work authorization, the expiration date problem that really nobody caught was what Brandon just said in the last slide. So we're not going to spend a lot of time on this one, but you have to make sure that the CDL expiration doesn't outlive the expiration of the work authorization. And that's really the key point here. But something that you should have always been done, like I said a few slides ago, is e-verify anyway, and using I-9s to verify employment eligibility. So that's the biggest piece, making sure that you're doing your e-verify, you've got records of that in your e-verify portal within the first 72 hours, and that you know that you're hiring legally compliant employees.
All right, English language proficiency. This is another one of those issues that's not a new issue. As FMCSA noted, English language proficiency has been a rule on the books, believe it or not, since the 1930s. There has been a requirement in whatever kind of motor carrier regulations existed at the time since the 1930s that required regulated drivers to be able to sufficiently read and speak the English language, to converse with law enforcement, to read road signs, to fill out their paperwork. It's not a new requirement. So what has changed? The thing that has changed within the last year is how aggressively the agency is going to enforce that requirement. This is something that unfortunately ebbs and flows. And it ebbs and flows with the politics of the issue. It has become a very politicized issue, and so you see changes in how aggressively it is enforced based on who happens to hold office at any given moment. So coming off of the last 10 years, we've had pretty lax enforcement of English language proficiency. Drivers would still get cited for it roadside, but it was not an out-of-service condition. So they could continue operating even if they were tagged with not being proficient in English. That is what changed starting with President Trump's executive order last April, and then FMCSA's new enforcement policy, which took effect in June of last year. That enforcement policy restores the out-of-service nature of English language proficiency violations. So now, anytime a driver is written up for an English language proficiency violation roadside, with a couple of caveats, which we can talk about if you're interested in, but the general rule is they will be placed out of service for that violation. They have to park it. They can't move on. And if they do move on, despite the out-of-service condition, then they're going to get a jumping and out-of-service order, which is a very serious violation. And so how is English language proficiency assessed? Well, this is laid out in the FMCSA's enforcement policy. You could read it if you wanted to. It lays out the test that law enforcement is supposed to conduct roadside to assess a driver's English language proficiency. The roadside inspections start off just like they always have, with the officer conversing with the driver about, hey, where are you coming from? Let me see your license, that type of stuff. And if in the course of that normal conversation, the officer thinks that the driver is struggling with English proficiency, they are instructed to kick off this two-part English language proficiency assessment. The first part is a driver interview portion, where the officer is supposed to ask a certain number of questions to the driver in English and instruct the driver to respond in English without the help of any kind of interpretive device or anything like that. The questions are laid out in the enforcement policy that they can ask. It's the questions you would expect in a roadside inspection. They're not. I've heard this rumor that they're like showing them a Cat in the Hat book or something and having them. That's not the case. There are specific questions they have to ask, and they are the questions you would expect in a roadside inspection. They are, where are you coming from? What are you hauling? Where are you at with your logs, that type of stuff. And the driver has to answer in English. And if they fail that first driver interview portion, they're placed out of service. That's the end of it. They fail the ELP assessment and they're placed out of service. If they pass the interview, then they move on to step 2, which is a traffic sign recognition test. The officer shows the driver a series of road signs. And again, these road signs are in the policy if you want to see which ones they show them. And it's random. I mean, they have a list of, 35 or so road signs they could show them, but they only show them, a handful. And the driver is instructed to explain the meaning of the sign in English. And the officer assesses the responses and the proficiency in English. And if they fail that portion of the test, then they're placed out of service. If they pass that portion of the test, then they've passed the assessment and they move along. So that's how it's supposed to work in practice. And we are seeing a significant uptick in drivers placed out of service roadside for these violations. I think FMCSA's data shows 17,000 drivers placed out of service for ELP violations in the last 6 months. And so, that's not a huge portion of the population of drivers, obviously, but it is significant. It's worth watching out for. And so as motor carriers that hire drivers, there are things you should be doing, as Rob's already pointed out. You should be assessing English language proficiency during your onboarding process and possibly with your existing universe of drivers that are already operating for you. At the onboarding stage, to your question earlier, you ask, if I assess English language proficiency, do I run the risk, and then I choose not to hire a driver because I don't think that they're proficient, do I run employment law type risks? Am I going to get sued for discrimination or something to that effect? I'm not an employment attorney, so I don't want to give you wrong advice, but what I can tell you is that if what you are doing as part of your onboarding process, whether it's English language proficiency or otherwise, if what you are doing to comply with federal law, a law that you are required to comply with, then you should not have employment law issues. So if your policy is, I'm going to assess your English proficiency, and if you're not proficient to my satisfaction, I'm not going to hire you, I think you would be fine from an employment law standpoint. Is that going to protect you from getting sued for discrimination? No, there's nothing that protects anybody from getting sued for anything. Anybody can sue anybody for anything. The real question is, how quickly can I get myself out of that lawsuit if I find myself there? And the defense that you would have in that case is, I'm just following my federal obligations to check their proficiency for English. The rules say that they're not qualified to operate for me if they're not proficient. I assessed them. They weren't proficient. I didn't hire them. That should be the end of this story. So I don't have much employment law heartburn from having an English proficiency assessment as part of onboarding. In fact, I think every carrier should have that as part of their processes, as part of their onboarding process. Some other things you can do from an English language proficiency standpoint to keep yourself out of trouble. Because the question we get asked a lot is, what if we have a driver who is found not proficient in English, they get placed out of service, how do I get them back in service if I want to keep them driving for me? That's the million-dollar question that nobody seems to have an answer for. I don't have an answer for it because the DOT doesn't have an answer for it, at least not that I've heard. CVSA, the law enforcement, they don't have an answer for it. How do you get these drivers back in service if they've been deemed not proficient? You could see the issue here is that this is such a subjective thing, right? What one officer here thinks is proficient, the next officer down the road might think is not proficient. So how, as the motor carrier or the driver in that situation, how do you handle that? Well, the best I could tell you is if you have a driver that gets sidelined for English proficiency and you want to put him back in the truck, you better have some evidence at your disposal that you did something about it. You can't just put him back in the truck and say, screw that officer. He didn't know what he was talking about. Because then you run the risk of a jumping and out of service order, which, as I said, is a very serious violation that could end up with criminal charges. You definitely don't want to go that route. So if you're going to keep them in the truck, you got to have something. The something I think you need to have is some kind of a substantial English language training program that driver has gone through. And it better be substantial. You'll probably see advertisements out there on the internet for like courses that have popped up, like a 30-minute English training course for drivers on how to be proficient. I don't know about you. I took 5 years of Spanish in high school, and I can't speak any of it after 5 years. You think a driver who is not proficient in English is going to be proficient after a 30-minute course? It's just not going to happen. So the thing I think you need to do is have a substantial English language training platform that they go through, that they get a certificate for, that they give you the certificate for. You put it in their driver file, then you've got some good evidence that you've done something about it to get it under control. So those are just some thoughts. Yeah, question here.
Along the lines of what she was saying, though, so as an employer doing the hiring for all of your safety sensitive CDLs, then would she need to put in place that every one of her drivers, so it's consistent across the board, not just like
Yeah, this is a good question, and maybe I misunderstood your question, but this is an important question you should consider. The question is, if I'm doing English language assessments, do I need to take care that I'm doing the assessments equally across the board for everybody that I'm onboarding, as opposed to nitpicking drivers who maybe have a Spanish-sounding name or that look like they are a foreign driver? That is something you don't want to be doing. Because I know that's going to, even though I'm not an employment attorney, I know that's going to run you into employment law issues, is if you are only administering the test to folks who have a last name that you suspect it means that they're a foreign driver or that look different. You don't want to be picking out, discriminating in that way. You need to apply it across the board equally to all of your new hires. Follow.
If this was a new policy, because we're a small family like that, but we're looking to grow. So if we did this because of the blanket, do I have to go and show that I went back to all the drivers who have existing
Yeah.
and retest them?
This is a question. Yeah.
They grandfathered in because they were prior to this being universal.
Yeah, the question is, that makes total sense from an onboarding perspective, but what about my existing driver pool that's out there operating now? Do I need to go back and retest them all to be consistent across the board? I would say probably not. It kind of depends on your fleet. If you're a small enough fleet where it is reasonable for you to be able to do that, then maybe it makes sense to do that. Not necessarily to be consistent, but more just to minimize your highway accident exposure.
Our specific company, we have 3 drivers,
Yeah.
myself, my husband, and my son.
Okay.
But
Do you all speak English?
we've had drivers
I'm assessing your English right now. It sounds pretty good to me. So.
yeah, my French is about as simple as your Spanish.
Okay.
And my Arabic's not so good, but my English is decent. But since they're all family members, since they were all raised here, they're all U.S. citizens, and like one of the biggest questions I'm getting from my customers, we're all TWIC, we're all citizens, we've all got military access. But now, even though not all my customers require TWIC or access to a military base,
Yep.
we're getting more and more requests from companies we didn't see it from before. Well, could you make sure you send us a U.S. citizen? Could you make
Yeah.
sure? They don't want somebody showing up, handing them the phone, and they talk to their dispatcher, and the dispatcher has to explain
Yeah.
it to them.
Yeah.
They will reject them if they show up and they can't understand and they start to.
Yeah, this is an issue that has, you're pointing out a concern that we hear from a lot of our clients, which is not only are we getting these issues from the DOT and from roadside inspectors, but we're also starting to see our customers push down requirements on us that say, we want to see proof that you've done English language proficiency assessments for your drivers, or we want to see proof that you've checked the citizenship status of your drivers. And you can understand their rationale if you just look at these news stories, right? These news stories that go out about drivers who get involved in these bad crashes. What's the first thing you see when you turn on the news? You see the trailers emblazoned with the names of the shippers, and so they are inevitably going to get pulled into these lawsuits. And to minimize their own exposure, they have to take steps to make sure that the carriers that they hire are doing the things that they are supposed to do so that the exposure doesn't filter up to them. So that's just something that we're going to have to deal with shippers and brokers pushing those requirements down on them. And to your question about what do we need to do to satisfy them, I think if you want to continue to do, there are things you do because the government tells you to do them, and there are things you do because your customers require them. I don't have much to say to you other than if you want to keep your customers happy and they're going to require those things, then you're just going to have to check the box to do them. You do them, yeah.
Prior, but like some of these things that we're implementing now that we want to grow, theoretically, I could go back and give my husband
Yeah.
an English test, and I'd have to give myself one, but it's going to look suspect. You tested yourself and you passed it.
Well, I mean, yeah, I mean, you're testing yourself, and I agree it looks suspect, but that's the way the regulations work. And so this happens with other things too, like road test, right? The DOT regulations or guidance specifically say, what if I'm a motor carrier that I'm the only driver? The regulations say you got to go get somebody else and test. It could be your brother. Have him test you and put that in, because it's a check the box type deal. And so to you, it's your family. You know that they're proficient in English, but I would advise you to just do it and put it in the file, just so you have it. Even though it's clear that you did it, there's nothing else you could really do. I mean, that's what the regulations require of you. So.
Based on the fact that we're also a hazmat carrier, one of the things that I didn't see you touch on, but that I do, and I don't know that everybody else does it,
Yeah.
is the restrictions on who we can insure are so strict.
Yeah.
I basically have them sign a waiver and give me a copy of both sides of their license and send it to the insurance company.
Yeah.
Because that's my first step. If they won't insure them, my conversation's over.
For sure.
There's no reason for me to go to the expense or do all the rest of it if I can't insure you to drive.
Yeah.
And
Yeah.
I've had people actually say, well, that's discriminatory. I'm like, dude, I didn't set the rules, but I gotta have insurance. Federal law says I have to have insurance, and they won't
Yeah.
insure you, and I'm not just gonna hire whoever just so I can put you on board.
Yeah. Makes sense.
Well, some of these pieces in terms of discrimination, no matter what it is, it's a policy thing. So you might want to make sure you've got good policies in place as well. I mean, it even goes towards medical qualifications if you change your medical policy. So one of the things that I put in place was you have to have a 1-year medical card or you can't work for me. And I did that for a reason. At that time, it weeded out diabetics. So I was protected by the policy. But in some cases, you want to make sure that you've got driver hiring criteria policies in place in terms of this is what we do for everybody. So
We got to, I apologize to cut you off. we got to wrap it up because we got the next group coming in here. So Rob and I will be around. If anybody has any questions that we didn't get to, happy to discuss them. Thank you all for being here. Really appreciate it. Sorry that was a very dense presentation. I know that the Matt's people are going to show the replay if you want to go back and watch it, or if you want a copy of the slides, come up and talk to us. We'll get it to you. But thanks for being here, everybody. Appreciate it.